Hello, this is California criminal defense attorney David Chesley. Today we will discuss the case of James and Jennifer Crumbley, parents of the Michigan school shooter, sentenced on April 9, 2024 to 10 to 15 years in prison for manslaughter. In a case that has rocked the nation, we summarize and analyze the situation of the parents of the teenager who unleashed a school shooting in Oxford, Michigan, back on November 30, 2021. In the case, the jury's verdict when it came to the parents was guilty. Their crime, providing their son unbridled access to guns and ammunition, a recipe for disaster that unfolded tragically. The presiding judge didn't hold back, pointing out their glaring negligence and utter failure to act despite the warning signs. It's like they had a ticking time bomb in their hands, and instead of defusing it, they handed it the keys to the city. The judge's words echoed in the courtroom, highlighting a parental failure of epic proportions. But this case isn't just about the Crumbleys, it's about setting a precedent, about holding parents accountable for their children's actions, particularly when they've played a part in arming them for those actions. Now let's put on our lawyer caps and dive into this legal pool of jargon, shall we? In the realm of law, the Crumbleys were charged with manslaughter, a term that may sound intimidating, but let's break it down. Manslaughter refers to the unlawful killing of another person without premeditation or intent to kill. In this context, the charge was brought against the parents for their negligence in providing unrestricted access to firearms to their son, leading to tragic consequences. But here's where it gets interesting. This case marks a significant legal precedent. For the first time, parents were held criminally responsible for a mass school shooting carried out by their child. This means, in the eyes of the law, parents can now be held accountable for their offspring's actions if they negligently provide the means for such actions. It's a case that could potentially change the landscape of legal responsibility and parental accountability. Now, if this were California, how would our legal system handle this? Well, in the Golden State, we have some of the strictest gun laws in the nation. Parents providing unrestricted access to firearms to a minor could potentially face serious criminal charges under Penal Code 25100. California Penal Code 25100 makes it a criminal offense to store a firearm in a manner that allows a child to gain access to it. This law, known as the Criminal Storage of a Firearm Statute, requires gun owners to keep their firearms in a secure location that is not easily accessible by children. In California, the Crumbleys may have faced penalties due to our stringent gun control laws and our laws on parental responsibility, but likely to a lesser extent. In California, parents can face legal consequences when their children engage in criminal activities. The state's parental responsibility law allows for criminal charges and penalties against parents if their minor children commit crimes. Additionally, parents may be held liable in civil court for any damage or harm caused by their children's actions. California Penal Code 272A2 PC holds parents accountable for their minor children's behavior. If the court finds that a parent should have been reasonably aware of their child's delinquent or potentially delinquent behavior and failed to take appropriate disciplinary, supervisory, or control measures, the parent may be charged with failing to exercise reasonable care or control over their child. PC 272A2 states that parents or legal guardians of individuals under 18 years old have a duty to exercise reasonable care, supervision, protection, and control over their minor children. While this statement does not explicitly mention criminal charges for parents based on their children's actions, case law has interpreted it as such. In the Williams v. Garcetti decision, the California Supreme Court ruled that parents violate Section 272 when they fail to perform their duty of reasonable supervision and control, resulting in their child's delinquency. The court stated that the legislature intended the supervision and control elements to describe parents' responsibility to reasonably supervise and control their children to prevent them from engaging in delinquent acts. To convict a parent of a crime under PC 272, when their child has committed an offense, prosecutors must prove the following. The parent knew or reasonably should have known that their child was delinquent or at risk of delinquency. The parent failed to take appropriate action to supervise and control their child to prevent the criminal behavior. Violations of California's parental responsibility law are considered misdemeanor offenses, effectively contributing to the delinquency of a minor. If convicted, a parent could face fines of up to $2,500 and up to 1 year in county jail. However, the state of California offers a parental diversion program, which may allow eligible parents to have the charges dismissed upon completion of a treatment or educational program, thereby avoiding jail time and a criminal record. As a defense attorney, it's worth noting that the Crumbley's conviction sets a precedent that could echo in California courtrooms. It signifies a shift in how we legally assess responsibility in tragic incidents like school shootings. It's not just about the act itself anymore. It's about the circumstances that allowed it to happen. This case could potentially alter how we approach similar situations in the future. It could lead to greater scrutiny of parents' roles in their children's access to firearms, and it could impart a greater sense of legal responsibility on parents to prevent such incidents from happening. So what do you think? Do you believe parents should be punished for the crimes of their children? Under what circumstances is this appropriate? Post your thoughts in the comments below. So there you have it, folks. A tragic tale, a historic verdict, and a stark reminder to all parents out there. Keep your guns out of reach and in a secure location that is not easily accessible by children. It is essential for parents facing such charges to contact a law firm to review the case details and discuss legal options. If you are facing similar charges such as these, contact the criminal defense attorneys at the law offices of David Chesley, and we will work to get the charges dismissed or reduced. We offer a free consultation. Call us at 800-883-9076, that is 800-883-9076, or visit us on our website at chesleylawyers.com.